are saying that they wanted the ability to continue to investigate NAR and have the terms of the settlement move forward, which is kind of like having your cake and eating it too. That was not the benefit of the bargain that NAR had reached as part of the settlement. It was that the investigation would be closed, and here are the terms on which the parties agreed to close that investigation. The DOJ withdrew from the settlement, which was unprecedented. NAR had never heard or known of a similar situation where the DOJ had entered into a fully approved settlement agreement that had been signed and filed with the court. So NAR in turn took another unprecedented move and filed a petition to quash the new civil investigative demands that the DOJ issued very shortly following their withdrawal from that settlement agreement. NAR's petition asked the court to end and close the new investigation that the DOJ had attempted to reopen and make a determination as to whether or not the DOJ or the government more broadly is required to adhere to and comply with the terms of an agreement that had fully executed, considered, and had been approved, just like any party to a contract would, right? There's two parties to an agreement, you sign it, you execute it, you're now bound by the terms of the agreement. So NAR asked the court to determine whether or not, similarly, the government, or more specifically, the DOJ, was also bound by those very basic contract principles. Just last month, after many months and well over a year of our petition pending in front of the court issued an order granting NAR's petition. Which the court essentially adopted and agreed with NAR's arguments, which was that if the DOJ was allowed to withdraw from the settlement agreement as it had, that NAR would have been deprived of the benefit of the bargain that it had reached as a result of that settlement agreement. The court did not say, and of course the DOJ is not forever precluded or foreclosed from opening an investigation into NAR, but there has to be some sort of intervening circumstance. Something substantial had to have changed, something material, like a rule change. Had there been a rule change to the participation rule or the clear cooperation policy, that would be the impetus for reopening an investigation into a matter that had already been investigated. So where are we now? We don't know. As I said, this is kind of unprecedented, but we don't have that settlement agreement because the DOJ withdrew that matter from the court when it withdrew from the settlement agreement. So there's no pending matter right now to go back to in terms of implementing the settlement agreement. The DOJ does have 60 days to appeal the decision by the district court in which the court granted NAR's petition. So that is certainly a possibility that the DOJ will appeal, and they have 60 days from the date of that order to appeal. So we wouldn't be looking for an appeal until sometime in March or late March. As I said, the settlement agreement really isn't moving forward, but you may or will now know that NAR did move forward with implementing 3 of the 4 rule changes that were part of that original settlement agreement, because we are always looking at our rules and trying to update them and make sure that they are best serving real estate professionals and consumers in the purchase and sale of real estate. So we did move forward with 3 of those key rule changes. What are those key rule changes? Number 1, there was a change to policy made that realtors may not advertise their services as free when they're provided in connection with real estate brokerage services. Prior to that, realtors could advertise their services as free, but they had to give a whole list of disclosures that made clear to the consumer or to anyone reading about the realtor services that that they were receiving compensation from some source. But now it is a bright line prohibition on advertising services as free when they're provided to a client in connection with real estate brokerage services. That does not preclude the provision of free services, prospecting services like a free CMA or something that you do to try to generate new business. The second key rule change was a prohibition on the filtering of listings based on the offer of compensation or the name of the listing broker or agent. Now, those are things that were already prohibited by the Code of Ethics, because Article 1 very clearly sets forth the obligation of a realtor to work in the best interest of their client. So certainly filtering listings or not showing listings or not informing consumers about listings that meet their stated parameters would not comply with that Article 1 duty. So that just is a bit more specific in carrying out that Article 1 duty. The third change that was implemented was the display of the offer of compensation. So now any MLS that has a publicly facing website must publish the offer of compensation on that website. MLSs also must enable participants to display the offer of compensation through an IDX feed. It is not a requirement that participants display the offer of compensation, but the MLS must enable MLS participants who choose to display the offer of compensation to be able to do so through the feed that they receive from the MLS. The last rule change, the fourth one that we did not make any changes with respect to, was the lockbox access rule. That required a bit more study in terms of what, if anything, needed to be done to address that. But we really point members back to the Article 3 duty, which is that realtors are obligated to cooperate with other brokers regardless of membership when it is, again, in their client's best interest. So providing access to a property either through a temporary lockbox code, physically opening the property, whatever the case might be, and a realtor has an obligation to cooperate regardless of the broker or agent's membership status when it is in their client's best interest. So Article 3 really covers what the intent of that fourth rule change is without having to make any new policy or rules. So that's the DOJ litigation. Right now, we are celebrating what we think is a very impactful decision that will have an impact and influence parties well beyond just even this case. It could very well change how the government, and specifically the DOJ, negotiates and enters into these types of agreements with parties, but it also gives parties the confidence that when they do reach an agreement with the government or the DOJ, that the terms and the government are obligated to uphold agreements that they've reached. So celebrating that victory, but just in terms of next steps, we'll be looking to see whether or not the DOJ appeals or what the next step might be. I'm happy to take questions as we move along, or I can just keep going through the other litigation. Okay, I don't hear any, so I'm going to move my slides backwards here to talk about the class action lawsuits. So since 2019, NAR has been defending 3 class action lawsuits. The first 2 are class actions filed by class action attorneys / home sellers, and the third lawsuit was filed by a home buyer / class action attorney. So I'm going to start with the 2 home seller cases, and those are the cases here on my slides that you can see. The Murrell and Sitzer case. Murrell was filed first. That was filed in the Northern District of Illinois, followed by the Sitzer case. And that case was filed in Missouri. It's a copycat lawsuit, very common in class action litigation that you see these copycat lawsuits. I'm going to start with Sitzer because Sitzer has moved along much quicker than Murrell. And that is maybe thanks or due in large part to the judge that we have the case in front of in Missouri, who was a former class action attorney himself. So that gives you kind of an idea of what we're facing there in Missouri. So both of these cases contain the same essential allegations. They challenge the same rules, including the mandatory participation rule, which you all know requires that realtors or MLS participants rather make an offer of compensation to other MLS participants who bring a ready, willing, and able buyer. That offer of compensation, of course, can be anything from 1 penny and above, and it is fully negotiable at any point other than that unilateral offer. The MLS participant that makes that offer cannot change that offer once it's been communicated and somebody brings that buyer. It would have to be a matter of negotiation, as you can imagine, as is typical in any contractual matter. It would have to be a negotiation point between the listing broker and the buyer broker. So in these lawsuits, home sellers allege that they have been harmed because they paid too much in commissions, that they pay inflated commissions, artificially inflated commissions, as a result of this mandatory participation rule and other rules, including a rule that I just mentioned, which is that the Code of Ethics previously allowed realtors to advertise their services as free, provided they made all sorts of different disclosures. But the home sellers, class action attorneys in these cases allege that as a result of NAR's policies and rules, home sellers are paying more in commissions than they should. And they point to several reasons why. They say that if the buyer were to negotiate the commission directly with their buyer representative, that they would necessarily negotiate those commissions lower. They also say that buyer representatives have a diminished role in the transaction because property information is so widely available on the internet, which we all know is due in large part to the MLS and the accurate information, up-to-date information that is compiled and then sent to various places where consumers have access to that information. They also point to other countries and say commissions are lower in other countries, so they should be lower here in the United States. It's comparing apples and oranges, very different ways of transacting real estate, countries where they don't even have an MLS, very different systems. But these are the home sellers' arguments. They allege essentially that there's been a conspiracy to price fix amongst participants. NAR is defending these lawsuits along with 4 corporate defendants. So we're not defending this alone. We are defending it with Keller Williams, Remax, Realogy, and Berkshire Hathaway Home Services. In Sitzer, as I said, both of these have been filed as class action lawsuits. So one of the major steps in any class action lawsuit is to certify the class. And that means that more home sellers are able to be part of the class of the litigation. The litigation is originally filed by 1 or 2 or a few named plaintiffs who then try to assert themselves as being able to bring this litigation on behalf of the whole class, which here in Sitzer is any home seller who has sold a home using one of 4 named MLSs within a certain time period. These 4 MLSs are not named as defendants in these lawsuits, but they're used to identify the class of potential home sellers that can be in this class. In the Sitzer case, we went through that phase. The court certified the class, which means more home sellers joined the class. Just this past summer, the plaintiffs, class action attorneys, have been doing a lot of notification and an advertising campaign about the lawsuit to alert home sellers of their rights as part of this lawsuit, as well as their ability to opt out of the lawsuit, which means that these home sellers can bring these claims individually if they so choose and not be part of this class. We were set to begin trial in this case actually yesterday, and it was to be a 3-week jury trial in Kansas City, Missouri. The trial, while we were singularly focused and had been for several months leading up to yesterday, the trial was postponed. It was postponed until mid-October. So between now and mid-October, there's not going to be much activity here. It's going to sort of sit dormant until mid-October, and several months before then, of course, NAR and the other corporate defendants will be gearing up again in preparation for trial. So that's where we are in Sitzer. Class certification granted, proceeding as a class action, jury trial scheduled for 3 weeks starting October 16th. Merle, everything I just told you about Sitzer is true in terms of the allegation, what's involved, what are the class action attorneys alleging. But this is more national in scope. So there are about 20 named MLSs, again, not defendants in the lawsuit, but there are 20 or so MLSs that are identified that are across the country which would identify the home sellers that could potentially be part of this class action. This case is in the class certification phase, but there's been no ruling on class certification here. The judge in Illinois is quite the opposite of the one in Missouri. She is notoriously slow, we'll say thoughtful, in making rulings on issues in front of the court. So the class certification question has been fully briefed and is pending in front of the court. And so we wait now for a decision on class certification in the Merle decision. In case you're wondering, just because Sitzer was certified as a class, it does not mean that Merle will be certified as a class. Of course, NAR and the other corporate defendants argued that this case is not appropriate for class certification, that is impossible and legally impossible for one or two or a few named plaintiffs to adequately represent the interests of all of these home sellers nationwide when every single real estate transaction is unique. And so we've brought those arguments to the court, and she is able to make her own determination on the appropriateness of class certification in this case. Given just how we're haven't even reached class certification, the next step will be, if it's granted, summary judgment. We wouldn't be looking at a trial until sometime in 2024 or beyond, if there is a trial in this case. So Sitzer trial, October 16th, Merle, we're waiting on the class certification decision. The third class action lawsuit is Leader, and that is a home buyer case. Here, Home Buyers Leader has filed a lawsuit alleging basically all of the same things that the home sellers did, and they challenge the same rules and policies, including the mandatory participation rule, and allege here that it's home buyers that are harmed because now home buyers are paying more for houses than they are actually worth. And that is because of the mandatory participation rule and the fact that the the commission is baked into the price of the home. So home buyers are harmed because now they're paying more for the home than it's worth because of this commission. Here, NAR filed a motion to dismiss in this case, and it was granted. You might recall that if you've heard previous updates or recall from last May. Our motion to dismiss was granted in this case. It was actually granted during legislative meetings, so we had very positive news to share during those meetings in a time when members were together. And the court granted the motion to dismiss without prejudice, which means that the court allowed the plaintiff to refile their complaint. But at the end of the complaint, the judge warned, I'll say, the plaintiff that the judge found it nearly, if not impossible, for the plaintiff to cure the deficiencies in the complaint. And so what were those deficiencies? Under federal antitrust law, indirect purchasers do not have standing to bring a federal antitrust claim. Buyers, by their own admission in the complaint, are indirect purchasers of the real estate brokerage services, meaning that they don't pay the broker directly. Just how the structure is. And so they're indirect purchasers of the services and thus do not have standing. And that was the basis on which the court granted NAR's motion to dismiss. Also, fun fact, or just fact in general, we're in front of the same judge in the Leader case as we are in Merle. So both of those cases are in the Northern District of Illinois. And so we're in front of that thoughtful but slow judge in the Northern District. So regardless or irrespective of the judge's warning about the lack of confidence in their ability to cure the deficiencies in their complaint, plaintiffs went ahead and filed an amended complaint. It's very common that the motions are granted without prejudice, so it's quite standard for plaintiffs to be allowed another bite at the apple, and they took it and filed an amended complaint. NAR filed another motion to dismiss in this case. We had hoped or anticipated a decision by now, but alas, the judge is slow, and did indicate, however, that the court anticipated ruling on our motion to dismiss before our next status hearing, which is set for the end of March. So we might have an update in this case sometime in the next month. So motion to dismiss pending here in the leader case. So those are the 3 class action lawsuits. Does anybody have any questions about the status or anything having to do with these cases?
Yeah.
Hi, Leslie. I'm Lisa Wade. Thank you for giving us this information. And you may have said this and maybe I didn't catch it, but regarding the Sitzer case, why was it postponed, or who asked for the postponement?
Yes, good question. I did not. One of the corporate defendants, Realogy, who's now known as Anywhere, requested that the court postpone the trial based on the concern that there could end up being 2 trials. And why would there end up being 2 trials? Home Services, which is another defendant in the litigation, has a pending appeal with the 8th Circuit regarding whether or not certain of the home sellers that would be included in this class are compelled to arbitrate their claims. So Home Services argues that some of these home sellers that would be part of this class have agreed to arbitrate their claims against Home Services, and thus should not be part of this class. And so Realogy filed a motion requesting that the court postpone trial so that we could allow time for the 8th Circuit to rule on this arbitration question.
Well, if Home Services wants to arbitrate potentially, will that screw up the rest of things for us? Because isn't that almost like them saying, yeah, sorry, our bad?
No. It's that they entered, when they entered into these listing agreements with home sellers, in that agreement, they had an arbitration clause, and the home seller said, we're not going to bring we're not going to bring litigation in court. We're going to agree to an alternative forum to resolve these disputes. And it wouldn't pertain to all of the home sellers, just potentially some of the home sellers. So rather than having the case proceed, and then potentially having to figure out after the fact, well, some of these home sellers weren't even part of the class, and what does that mean if the plaintiffs were to prevail in terms of damages and calculating all of that? Realogy filed a motion asking that the court delay. What it did do, I would say, is that, as I said, NAR and other corporate defendants were very focused on preparing for trial, which, as you can imagine, is a very intensive process, and there's a lot that goes into it. And so we had been very focused on that up until just a couple months before trial was scheduled to begin. So we have to kind of redo all that work now as we get closer again to the new scheduled trial in October, but we will do that again. We will undertake all of the same efforts so that we can really refine and understand what will resonate best with jurors to make sure that they understand the landscape here, that there is no anti-competitive behavior that's taken place. So that's really the result of the delay in the trial. But whether Home Services has an arbitration agreement with some of its home sellers does not, in and of itself, disadvantage the rest of the corporate defendants.
Okay, thank you.
Yeah.
Leslie, Brett Sawyer here. Thank you so much for spending your time with us. Beyond educating our members of these cases, rather, what do you and NAR recommend that we as an association do to assist our members with this dynamic?
Yeah, no, thank you for the question. It's a very good question, and I'm happy to have the opportunity to respond. So it's really helpful for you all to understand what's happening in these lawsuits. It's helpful for members to understand that these lawsuits are happening. It's a lot of legal information, a lot of legal terms. So is this something that we need members to be out there talking about with consumers, specifically the lawsuits? No. So what we need to do, you all can do, and what would be most helpful is educating realtors to be able to talk about their value and about the issues that surround these cases, which are how real estate professionals are compensated. What are the services that are provided? What is the value of using a real estate professional? Because all of these cases threaten or challenge all of these ideas about the value that a real estate professional brings to the transaction, about how they're paid and what they're paid for, and whether they're even necessary. And we all know that they're necessary. We all know that real estate professionals, realtors bring value, but consumers don't understand it. And so perhaps we haven't been as good at communicating our value proposition to consumers to help them understand what the real estate professional or realtor brings to the transaction. And very specifically, what the MLS is. I think we all take for granted that we understand what the MLS is. We understand how it operates. We understand how it creates all these advantages for consumers, but consumers don't. A lot of consumers don't even probably know what an MLS is. And they don't know how it's working for their benefit. And so part of the messaging that our members can do to help us here is helping consumers understand what the MLS is, how it works, why it works for their benefit, how they're paid, what they're paid for. So using buyer representation agreements, NAR has for a long time advocated that our members use buyer representation agreements, regardless of whether they're required in a particular state. And it's really, as we understand it, very locally based as to whether or not real estate professionals are using buyer representation agreements. But they really will leave, if you use one, it leaves no doubt about the transparency that real estate agents have, real estate professionals have with respect to their compensation. It allows for those conversations to happen upfront with consumers so they understand what are they going to get paid for their services, who are they going to get paid by, and what are they providing to the consumer. So it's all about transparency, education, making sure consumers understand that commission is negotiable. It is negotiable. There's nothing in NAR's rules or policies that prohibit the negotiation of commission. The attorneys in these lawsuits are twisting and contorting our policies and rules to say otherwise. And so the best that you all and our members can do to help us here is, as we say, help us win in the court of public opinion. If we have members or other individuals who want to do op-eds in local marketplaces to talk about these issues, we've had great success working with members to have those op-eds and pieces put out into the local newspapers and publications so that consumers are starting to understand and hear about and understand what real estate professionals are doing. So I'm hoping and assuming, but maybe I shouldn't because assumptions are never safe, that you are familiar with competition.realtor. That was launched a little over a year ago, and that should be the resource that you all share and promote with members to help them understand these issues. They're not going to talk all that specifically about the lawsuits because that's not really what we want members to be talking about. As I said, we want members to be talking about the issues surrounding the lawsuits. So on there's lots of resources, infographics, shareables that are intended for our members to take and use with consumers and talking with them. So infographics about how commission works, what the MLS is, what the services real estate professionals provide, how they work as advocates in their community and for private property rights, and just everything about how realtors bring value to consumers. So that is what you all can help us do to help win these lawsuits, because it really is a dual fight. We are fighting in the court of law, and we need our members, almost 1.6 million members who are the closest to the consumers, who can start talking about and educating consumers about these issues. So there's no doubt about the value of realtors and the transparency of realtors when it comes to working with consumers.
Other questions?
I have a question. Hi, Leslie, it's Veronica Priscilla. And my question is, the class that's been certified, and if Mueller gets certified, I think we're all thinking about when those commercials start to assemble the class. Where does that come in the process? Like the class is certified, do they now, and the trial comes up, what happens with trying to get more people in the class?
Yeah, so these class actions are actually opt-out. So if or when the class is certified, the class is certified as to all home sellers as defined, really by home sellers who used one of the named MLSs in these lawsuits. So in Missouri, as I said, there's 4 identified, I'll say, MLSs. So any home seller who sold using one of those MLSs that is in around in or around Missouri are automatically included in the class. So once the class is certified, the class action attorneys have obligations to fulfill in terms of disseminating notice that the class action is proceeding, it's been certified, and to notify home sellers about their rights. So it's sort of like the class is already created once class certification is granted, and then home sellers at their option can opt out to preserve their legal rights to pursue action if they so choose. In response to the class certification in Merle, we established another website. It's realestateCommissionFacts.com. So I encourage you all to look at that. Again, you're not going to see specific reference to the lawsuits there. But what it talks about is commission. It's commissionfacts.com. It talks about commission, the structure of commission in the real estate industry to help educate consumers, to hopefully help educate them about whether or not they actually want to be part of this class and potentially opt out of being part of this class of plaintiffs that's filing these lawsuits, these frivolous, I will say, lawsuits against NAR and the corporate defendants. Does that answer your question?
Yes, so I'm assuming that means we won't be seeing any commercials on late night TV about mesothelioma or whatever.
You will, okay, so you will not, because right now it's just Missouri that you will be seeing those types of advertisements. And I don't know if they had actual commercials on the TV, maybe, but they were like billboards, social media advertisements in the local newspaper. But unfortunately, what you could see is, and not precluded here, is that other class action attorneys could be establishing sites or commercials to potentially drum up a new class action lawsuit. And unfortunately, we have seen that popping up in a couple of areas, not Colorado. But like I said about Merle and Sitzer, copycat litigation in class action lawsuits is very common. So there may or could be continuing attempts to drum up another lawsuit. But no, for now in Colorado, you will not see this. But hopefully what you will see and hear is that members are out talking to your communities and consumers about these issues that surround the cases.
Great, thank you.
Leslie, if I could sort of put all, David Scott, if I could put this together, it looks like that we're not going to see any kind of a decision or something that's going to impact us at least until the end of this year, more likely probably in 24, 25. Is that reasonable?
It is, because regardless of, so Sitzer would be the first or the earliest we're going to see any sort of like final decision in the two home seller cases. And regardless of what happens in the Sitzer trial, there's going to be an appeal. If we win, the plaintiffs will appeal. If the plaintiffs win, we will appeal. So it is going to be a long process before we reach any sort of final conclusion to these lawsuits.
Thank you.
Unless, for example, the leader motion to dismiss is granted and plaintiffs don't refile. And unless the Merle case, the class certification is not granted, that case will become very much less attractive to the class action attorneys who are really behind these cases and are in it for that large payout that comes with class action lawsuits. So yes, Sitzer trial is going to be kind of the first maybe landmark decision, but then there's going to be a whole appeal process that follows that.
Thank you.
Yeah.
Leslie, can you hear me?
I can.
I've been kind of, okay. This is Teresa Lomax. I've been kind of listening from the Zoom call. One of the questions that I have that might be outside of your wheelhouse, as far as the legal thing, is with all of these other companies that are involved in the lawsuit and NAR, are there any kind of proactive communications on a national level that are in the works to educate consumers about the value of realtors?
Yeah, I mean, NAR is doing a lot, and that really goes to competition.realtor. There's a section on competition.realtor called In the News. You can see all of the publications and news articles that we're doing. We're conducting a lot of positive publicity for realtors, specifically in Missouri, as we were gearing up for trial, and will continue to do as we gear up for the postponed trial. So again, you're not going to necessarily see the lawsuits mentioned, but you will see realtors being promoted in various news articles, promoting the Good Neighbor Awards, just being present and being a vision in the community of positivity and the value that they bring for communities specifically. So there's very much a large mechanism behind the scenes that's happening to get the realtor name and positive information, correct information out to consumers across the country.
Great, thank you.
Mm-hmm.
Anyone else?
Thank you so much.
Leslie, thank you so much for your time and the information. And unless anyone else has any other questions, comments?
Well, I think all these particular NAR websites and things that she mentioned, Veronica, should get out to us so we can get it out.
Yeah.
Absolutely.
And
Yeah.
numerous times in the BNN, but I will continue, like with all things, you're never done communicating.
Right. I'm just dropping in the chat. I don't know who can see the chat, but I'm dropping the 2 websites that I mentioned.
Yep.
realestateCommissionFacts.com and competition.realtor.
I did make note of both of those, and we will continue to push those out to our members.
Awesome. And, I'll also put my email address in here because I would love to hear from any of you. If you have questions, follow up, or having trouble finding any resources, please use me as a resource on any of these issues or anything that NAR Legal can do for you.
Beautiful. Thank you.
Thank you.
All right. Thank you. Enjoy the rest of your day, and hopefully the weather stays okay or gets better. All right. Have a good one. Bye-bye.
Hey, doggies.